and a very good day to everyone. Assalamualaikum warahmatullahi wabarakatuh. My name is Khairunnisa Izzati.
I am Siti Nur Bakyah.
My name is Syahirah Nadhrah.
And I am Raudahtul Jannah Ismail. We are from Group 4 of KAT.
And today we are going to present
on the case of Phang Swee against Hock.
So I will start with the background of the case. The case citation is Phang Swee against Hock, 1964, 1 MLJ 383. The appellant for the case is Phang Swee, while the respondent for the case is Hock. The judges for this case is Thompson LP, Barakbar CJ of Malaya, and Tan Ahtar FJ. The counsel for the appellant is PP Dharmananda, and for the respondent is EK Yip. The court for this case is Federal Court, and the appeal number of this case is Civil Appeal Number 32 of 1964. The date of judgment is 1 September 1964.
The material facts for the case of Phang Swee against Hock is as follows. During the Japanese occupation in Malaya in 1944, the respondent Hock has agreed to transfer his half share of his land to Mr. Hock with the amount of 20,000 Japanese currency. The transfer of the said land has been made between both of them, however, it was not being registered at the land office. In 1946, Mr. Hock accidentally slipped off from a cliff, which resulting to his death. He died interstate. After the tragic incident, the appellant, Phang Swee, who is also the widow of the deceased, continued to possess the said land. Later in 1951, Phang Swee extracted the Crown Land of Administration from Mr. Dharmananda to continue her possession of the land. In 1958, Hock has made an agreement to transfer the name of the land to Phang Swee in exchange of $500. This agreement between both parties has been made orally. However, sometime in 1963, the land was divided into two lots. Hock has become the sole owner of the said land. In January 1963, Hock and his solicitor notified Phang Swee that she had trespassed the land. They asked her to immediately vacate her possession of the land as well as for an account of all income that she has received from the said land. Later in May 1963, Hock has initiated a legal action against Phang Swee, claiming that the agreement made between both parties back in 1958 was not legally binding. Hence, the issue in the case of Phang Swee against Hock is whether there was a legally binding agreement between the appellant and the respondent.
The ratio decidendi of this case is when the judge commented that there are considerations in the agreement. In Section 2, Subsection D of the Contracts Malay States Ordinance 1950 has allocated that when at the desire of the promiser, the promisee or any other person has done or abstained from doing or does or abstains from doing or promises to do or abstains from doing something such act or absistence or promise is called a consideration for the promise. The respondent also agreed to transfer the land to her on the payment of $500 when the land was subdivided, and in consequence, she took no further action in the matter until receipt of letter. In her evidence back then in 1963, she said that, "I am ready and willing to pay $500 if transfer is made to me. If plaintiff refused to transfer the land to me in 1958, I would have gone to my solicitor to take action." On the head notes of this case, there are three other cases that share similarity with this case. For the first case is the case of Robertson against Minister of Pensions 1949, which has allocated that assurances are enforceable, assurances are binding on the Crown, and assurances are binding on the Minister of Pensions. And the second case is the case of the Alliance Bank Limited against Broom, through Section 26, Explanation 2 explains on the inadequacy of consideration. For the last case is the case of Kedari bin Ranu against Ahmad Rambat 1866, which has allocated that mere inadequacy of consideration. It is true unless it be so great as to amount to evidence is not sufficient ground for setting aside a contract or refusing to agree a specific performance of it.
Next is the decision of the case. In the summary of this case, it shows that there was adequate consideration in this case. This can be seen from where the respondent agreed to transfer the land to the appellant when it was subdivided with the payment of $500. Therefore, the appellant is then entitled to the declaration sought by her. Not only that, Mr. Yap himself also agreed that there was consideration in this case. Therefore, inadequacy of consideration can be counted as unacceptable or immaterial. Next, the Section 25 of Indian Contract Act is counted as identical to Section 26 of our Contract Ordinance. Therefore, it can be proved that there was no evidence of fraud and duress in this contract and in this case. After all the given explanation, the judge then decided to allow the appeal with cost. The cross appeal made by the respondent is then dismissed, and not only that, the learned judge decision regarding the inadequacy of consideration in this case is then set aside. Thus, the appeal is allowed.
Next, for this case referred to 3 other cases, which are: first, Robertson's against Minister of Pension 1949 1 KB 227. The second case is the Alliance Bank Ltd against Prom 62 ER 631. And last but not least, this case referred to the cases of Kedari bin Ranu against Atma Rambat 1866 PH CAC 11 1890. There are 2 legislation which are referred to. The first one is Section 2D of the Contracts Malay States Ordinance 1950, and the second one is Section 26 of the Contracts Ordinance.
That is all from us. Thank you.